Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Today's topic is going to be, what is the difference between intestate and testate? But before we dive into that, if you have any questions pertaining to estate planning or probate and you want to schedule a free strategy session over the phone with me, head over to njestateattorney.com and schedule a day and time that works best for you. So, intestate and testate. Two terms that people get confused highly, and that's why we're here to educate you on what this means. So first, we're going to start with testate. Now, the simple, and I like to say keep it simple, stupid definition, is testate means you died with a will. There you go. You had a will, you died with it. You're testate. Which means when you head to the probate process, the court's following the will. Your executor's following the will. The laws of the state of New Jersey do not apply. They apply, but you're not going by their succession. You've designated how you want things to be done. Awesome. You've carried out that task. Now, intestate. This means, the keep it simple, stupid version, means you died without a will. So, you're probably going, David, so then what happens? So, funny thing, everyone has a will, and they're called the laws of the state. So in New Jersey, we have intestate succession laws. And what this means is if you die without a will, you've died intestacy, which means you have a slightly different, you're not going through probate, you're going through administration. It's the same thing. Let's be real, folks. Don't let that wording, the probate and administration, mess you up. You're doing the same thing, really. Just you have to go by the laws of the state of New Jersey. And these laws are basically what they're designed to do is to allow for a uniform, formal transfer of property from the decedent to a living individual. So how these work is basically the law would look to see, did you have a spouse? Did you have children? If you had a spouse, everything gets transferred to your spouse. If you have children, and in theory, if you have a spouse and you have children with that spouse, your children would be inheriting anyway through that spouse. If you didn't have a spouse, we look to children. If you don't have children, then what we really start looking at is then were your parents still alive? Did you have brothers or sisters? And then nieces and nephews. So the thing is, the law does cut off at a certain point, and it says, if you got nobody, guess what? The state of New Jersey is taking everything, and we want to avoid that. So even if you have nobody, what I would always recommend is create a will. You can leave things to charity. You can designate things to friends. But in intestacy, your friends are not going to be viewed at because they are not, as I would describe, some sort of blood relation. And that's really what we're looking at here is, or was there, we could have children through adoption. So was there a legal relation or a blood relation that would allow for this to take place? So we don't want the state to take your stuff. Just to backtrack really quick and to summarize what we've talked about, testate, you've died with a will. Intestate, you died without a will. Those are the cleanest and easiest ways to tell you what those words mean. I hope you found this video informative. If you did, please hit that like button. Head on over to YouTube, Instagram, TikTok. We're putting out content over there too. NJ Estate Attorney. If you have questions about this topic or any other topic in estate planning or probate and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com and schedule a day and time that works best for you. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.